Hello, this is Alexander Cross, criminal defense here in the San Francisco Bay Area. If you'd like to learn more about criminal defense, don't forget to subscribe to our channel, Law Offices of Cross & Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos for you. So, we received an interesting inquiry here on our YouTube channel. This has to do with a recurrence of domestic violence. Let's see here. 6 years ago, I was accused of domestic violence by my ex-girlfriend. I changed my life, but today I was arrested again for hitting my new girlfriend. Alright, okay, well, it says right here you were accused of domestic violence by your ex-girlfriend 6 years ago. Were you convicted of it? And were you formally accused? Because you might say accused, but did she really just say that you did it? Did you actually get arrested? Because let's say she just said that you did it, but you never got arrested, it's not going to affect you. If you got arrested, your arrest record technically could be used against you by the DA, but that's rare. They usually go with convictions. Now, let's say you were convicted of that domestic violence case 6 years ago. That's a problem, because in your new case, the DA will use that old domestic violence against you. They can use any conviction that's less than 10 years old. As a matter of fact, if you received a strike, it doesn't matter if the conviction was 30 years old, they'll try to use it against you, and you'll have to file a Romero motion to say that it's not particularly relevant because of the age. But since we're talking about something that's 6 years old, it can be used against you to show that you are somebody who has a propensity to commit this type of offense. In this situation, it's going to be extremely important to be quiet. Remember your Miranda rights. You have the right to remain silent. Anything you say or do will be used against you in court. You have the right to an attorney. If you cannot afford to pay for an attorney, they will assign you a public defender. Please, please, please be aware that people have this idea that to be accused of domestic violence, you have to impact the victim. No. Simply touching. Remember, a simple battery. Simply an offensive touching. It doesn't have to be a harmful touching. An offensive touching is enough. Against your spouse or girlfriend or ex-girlfriend, doesn't matter. A simple touching that was unwarranted could be basis for you to be charged with a misdemeanor domestic violence under Penal Code Section 243, parentheses E, parentheses 1, which carries up to 1 year in county jail, plus having to do domestic violence classes, 52 weeks, 2 hours a week. Really just exercise your Miranda rights, remain silent, let the attorneys order all the record, let them get the discovery, let them talk to the DA, see how solid it is, and it really makes a difference too on whether or not there's any physical evidence. Obviously, because if the victim has marks on her face and broken ribs and stuff like that, you can have a major problem there, because you could be charged with a 273.5 felony plus a GBI clause, great bodily injury, plus they're going to use the prior against you. It could become a mess. Now, it could also be a he said, she said thing where she just made it up, in which case, let the DA see if they could convince a judge that there's probable cause at a preliminary hearing, and if so, okay, well then maybe it can go to jury trial. What they'll do is they'll have to bring in 12 people from the community who will listen to all the evidence, and then they'll decide whether or not you're innocent or guilty beyond a reasonable doubt. Regardless, if you'd like to learn more about criminal defense here in the San Francisco Bay Area, don't forget to subscribe to our channel, Law Offices of Cross & Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos. But if you've been accused of a crime here in the San Francisco Bay Area and need representation, call us now for a free consultation at 1-800-862-7677. Once again, 1-800-862-7677. Criminal lawyer, criminal lawyers. DUI lawyer, DUI lawyers. Criminal attorney, criminal attorneys. DUI attorney, DUI attorneys.